Hi, good afternoon, everybody. Thanks for joining us on a cold and still snowy day in Washington, D.C. Hope everybody who's been affected by the storm is managing as well as you can. And we appreciate you setting aside some time this afternoon to join us for the 2025 GovCon Year in Review webinar. We're really lucky because we've got a dream team of partners from our GovCon group here, and then they let me join as well. So I'm really glad to introduce my colleagues, and let's go ahead and get started.
Good afternoon, everyone. Thank you for joining. My name is Meghan Leemon. I'm a partner in our government contracts group, like everyone else on this lovely panel is. I focus primarily on small business issues, and that's what I will be discussing today. So looking forward to it's a crazy time out there right now for small businesses. So we'll dive into a little bit of what happened in 2025 and then looking forward in 2026 as well.
Good afternoon, everyone. My name is Eric Valle. I'm also a partner in our government contracts group. My practice spans the full life cycle of government contracting, and I have a particular emphasis on government contract litigation, including bid protests. So I'll be addressing bid protests in 2025 and looking forward to next year on our topics today. And I'll turn it over now to Lauren.
Thanks, Eric, and good afternoon, everyone. So I'm Lauren Brier. I'm a partner at PilieroMazza. I lead the REAs Claims and Appeals practice group at the firm, focusing specifically on contract disputes on the contract administration side. I often appear at the Board of Contract Appeals and the Court of Federal Claims on behalf of federal contractors involved in disputes. I advocate for the rights of contractors dealing with constructive changes, unjustified terminations, and oftentimes with cure and show cause notices. And then I most recently have been assisting a lot with stop work REAs as well as termination settlement proposals. So I'm going to be talking about a lot of that today and look forward to speaking with everybody.
Thanks, Meghan and Lauren and Eric. And I'm Jon Williams. Like I said at the outset, I'm also a partner in GovCon. Been here 20 years and really proud of the fantastic GovCon team that we have here at PilieroMazza. We can go ahead and flip over to the PilieroMazza slide. For those of you who may not be familiar with our firm, we're a full service national practice. We help clients in a wide range of issues that includes M&A and litigation and labor and employment. I think what we're most well known for is our government contracts practice, where we're doing everything under the sun for government contractors. And you can see a lot of it on the slide here. And as we go over to the next slide now, that was sort of the brainstorm behind this webinar. Let's talk to folks about what we were doing in our GovCon group last year. It was a very active year. We had a lot of different matters. It was a very challenging year for contractors and the environment. Was difficult in many respects. There were also opportunities in what happened last year. So we wanted to spend some time, although I know, probably a lot of us, we got to the end of 2025 and we'd like to just keep that year in the rearview mirror. But there are some things we can learn in looking back at 2025. Make sure we understand some of the important changes that happened, and then how's that going to impact us moving forward. So that was the brainstorm behind this webinar, while we wanted to get these different partners from our group together to talk to you about some of these different areas of their expertise. And it's a longer than usual webinar. We're scheduled for an hour and a half. We know that may be hard for some folks to hang in the entire time. So that's why we put the schedule up here. We're going to do our very best to stick to this schedule. So if there's certain parts of the update that you're most interested in, you want to make sure you're here for that. We're going to start off with Meghan's review of the small business programs until about 2:25, and then Eric's going to talk about bid protests, and then Lauren's going to talk about REAs, claims and appeals, And I will wrap up with sort of a grab bag of regulatory and legislative developments, CMMC, the FAR rewrite, 2026 NDAA, et cetera. And then, as we go along, we'll do our best to answer questions. So feel free to use the question box to fire away, and we'll answer them as we go if we can, and then we'll try to save some time at the end as well. All right, with that, I'm going to turn it over to Meghan, and thanks again, everybody, for being here.
Looks like we are right on schedule. It's 2:05. I am going to talk for about 20 minutes or so on small business programs. I know there's a lot going on, especially right now involving the 8A program. But given that we're kind of talking about a year in review, I do want to take a step back and kind of start with where we started last June. Sorry, there's a typo on there. That should be January 17th, 2025. But we will go back to January 25, touch on the proposed and then final rule that went into effect early last year, continue on with some of the other proposed changes that have come out, a few OHA cases that I just wanted to highlight and note. I'll get into the 8A program for sure, and then briefly touch on the FAR Part 19 rewrite. So this is obviously a pretty high level overview, so I'm not going to touch on every single thing that happened in small business. I could probably be here for 8 hours. So if there's anything you have a question regarding, please put it in the chat. We may or may not be able to get to it, but that's kind of a high level of what I'm going to go through in the next few minutes. So first, I'm going to talk about the January 2025 final rule, which was entitled Hub Zone Program Updates and Clarifications, and clarifications to other small business programs. So while this rule was kind of highlighted in the Hub Zone program, it touched on a number of other areas that affected all small businesses. So at a high level, one of the things that SBA set out to do was to harmonize the ownership and control requirements across the various socioeconomic programs. In this particular case, there are very specific ownership and control requirements for the 8A program, the women or economically disadvantaged women-owned small business programs, as well as service-disabled veteran-owned small business and veteran-owned small business program. There were a lot of consistencies, but a few inconsistencies in terms of what it means to be owned and controlled by a qualifying individual for these programs. So certain things that SBA updated were things like ownership and control of a partnership, distribution of profits, highest compensation. That was a requirement in the 8A and SWSB programs, but it wasn't in the WSB program rules. Now it is. SBA has also implemented a requirement for companies to notify SBA within 30 days if there is a change to that compensation. And they also updated the regulations to require that the qualifying individual or individuals, if you're relying on more than one, must reside in the United States. There were, of course, as it goes with the name, big changes to the Hub Zone program. I'm not going to get into all of those, but SBA did change a number of definitions as it applies to the Hub Zone program, such as principal office, requiring a lease at least 30 days before the relevant date of review and at least 60 days after the relevant date of review. There were big changes to how an employee is defined, which is different, like in general employee versus an employee for Hub Zone purposes. SBA revised the regulations to provide that an individual, generally speaking, has to work at least 10 hours per week during the 4-week period. So you couldn't have a situation where the individual worked 40 hours in 1 week, but only worked for a company for 1 week. And then the 3 other weeks, who knows what they were doing. You also have to provide documentation of work performed. This could be for all employees, but typically in my experience, SBA requires this for individuals who are less than full-time. And just like a payroll record or time card is not going to be sufficient in order to establish that there was legitimate work performed. SBA did change the residency requirement from at least 180 days to 90 days. So they shortened that time period, which is a welcome change. And one of the biggest changes was regarding the date to determine eligibility. So once upon a time, HubZone companies had to be eligible as of date of initial offer and award. That was incredibly difficult because who knows when a government contract is going to be awarded. Then it changed to your anniversary date, just 1 year or 1 day every year that you had to qualify. This has now kind of gone to a little bit of a middle ground. Companies have to be HubZone eligible as of the date, generally speaking, of initial offer, including price. So this was a big change that has gone into effect as it pertains to the HubZone program. Another big change that came about through this final rule was the change to negative control requirements or restrictions. Importantly, in various socioeconomic programs, there was a different requirement for what it meant to be controlled. How much control could a non-qualifying owner have over a company's business operations? And the answer was different depending on if you were a small business or if you were seeking certification as an 8A WSB or an SDWSB, or also EDWSB and BOSB. SBA has done a complete overhaul on this particular requirement, and it is consistent across small business programs. So this was a really, really big change, especially for companies that were looking for minority investors. Made it maybe a little bit more attractive for minority investors from a control perspective, because SBA did revise the regulations to allow for a minority owner to have essentially a veto right or a negative control right over things like adding a new equity stakeholder, dissolving the company, selling the company, merger, declaring bankruptcy. And then also SBA included a catch-all provision. So essentially that states any other provision that's crafted solely to protect the investment of a minority shareholder, and that doesn't impede on the majority owner's ability to control the operations or conduct business as it chooses. So as you can see, there's a little bit more or a lot bit more flexibility given depending on which program you're looking at. So that was a pretty big and significant change that went into effect early last year. Something else that I wanted to highlight, because we often get a lot of questions in terms of for joint ventures, what can an agency require from a past performance perspective? So before this clarifying rule, it seemed like agencies had to, through protest decisions and whatnot, require some level of past performance from each party to the joint venture. Through this final rule, SBA clarified, no, that's not the case. The agencies have discretion to require some level, but they don't have to require past performance from a qualifying party in a joint venture. The next big piece of this final rule that I wanted to touch on was the changes to the recertification requirements. This was obviously a very, very big change as well, and we're still kind of seeing the effects of that change, especially through M&A deals and things of that nature. So previously, when a company was required to recertify size and status, was housed in each socioeconomic program regulations and so forth. SBA got rid of all that, combined everything into one regulation, 13 CFR 125.12. As you may or may not know, recertification is required within 30 days of a merger, acquisition, or sale that results in a change in controlling interest. Importantly, this is required from both the company that's being acquired and the company that's doing the acquiring, if those companies have received an award as a small business. Companies are also required to recertify no more than 120 days prior to the end of the 5th year on a long-term contract, anything over 5 years, as well as potential recertification at an individual order level under an IDIQ contract. The revised regulation breaks this down into qualifying versus disqualifying recertification. And the impact of that does depend on whether or not, generally speaking, the contract is a single or a multiple award contract. So a qualifying recertification, you're recertifying as small. Generally speaking, that means you're good for up to 5 years unless there's another triggering event. On a disqualifying recertification, you have to first ask yourself whether or not award has been made, and if you're within 180 days of the date of offer, generally speaking, you're not going to be eligible, and you cannot recertify. You're not going to be eligible for that contract. If you're more than 180 days since submission of an offer, it does depend on whether or not the contract is single or multiple award. If it's single award, you are still eligible. The agency just can't take credit. If it's multiple award, you're not eligible. There's also, in terms of if this happens after award, the impact of that depending on single or multiple award contract as well. And if you've been acquired by a company that is small under the NAICS code, or if you've been acquired under a company that's large. The difference, again, really does depend on the small versus the single versus multiple award contract. There was, as you may know, there was a delayed effective date for certain transactions that occurred before January 17th of this year. We are now past January 17th, so any new transactions are going to be subject to this recertification rule. So next, after that final rule that went into effect in January, SBA published a proposed rule in August regarding size standards. So, and this was specifically for receipts-based size standards. SBA proposed to increase the size standards for 263 industries and retain, so just keep the size standard for 237 industries. This rule is still pending. It hasn't gone into final, but hopefully something is coming in the relatively near future. I did want to take this time to remind you that because we're in a new year, assuming you use a calendar year as your fiscal year, your size has now changed. You are not allowed to wait for your 2025 tax returns to be filed to calculate your size. Obviously, you probably don't have tax returns available yet, so you need to rely on kind of the next best thing. Do you have in-house financial statements? But I do want to reiterate that you are now to be calculating your size, assuming a calendar year as your fiscal year, using 25, 24, 23, 22, and 21. If you have tax returns available, generally speaking, the calculation is done by looking at 2 line items on your tax returns, total income plus cost of goods sold. You do that for each year that's in that calculation, and then you divide by 5. It is a 5-year average. And you may find that you could be large now, given your financials from 2025, but maybe based on the proposed changes to the size standards, you could potentially come back into small business status if and when those proposed changes go into effect. Again, this is so, sorry.
Oh, I'm sorry, Megan. I just wanted to jump in to kind of echo what you just said, because I think we hear very often from clients that are surprised that they have to include the most recent year before their tax return is ready. I think there's a misconception that until my tax return is ready, I don't include that year. But I just want to make sure everybody heard loud.
It's a huge point, so it's worth reiterating for sure, because that is a common question that we receive. So I wanted to highlight you need to recalculate now using 25. If you operate under an employee-based size standard, there have supposedly SBA's proposed changes to those are coming soon. I don't know what soon is, so we'll see. We can go to the next slide. So just a couple of OHA cases that I wanted to highlight. A few years ago, there was a change to the ostensible subcontractor rule. And there was a recent case on this last year, essentially that other than construction contracts, if a small business prime contractor is complying with the limitations on subcontracting, then it should be deemed to be performing the primary and vital requirements. Now, if you're subject to a protest on this, you would want to be able to provide tangible evidence, things like invoices, subcontracts, or a teaming agreement, something detailing the value of the tasks that will be performed to demonstrate and confirm that you will be performing the prime, at least whether it's 50% or 25%, depending on the NACE code. There's a couple joint venture cases. Generally speaking, on the 2-year rule, we get a lot of questions on, okay, well, how can I use my joint venture? So this case was interesting because the joint venture was awarded its first contract many years prior, but the contract was terminated before any work was performed. So the lower level at the SBA didn't count that as an award for purposes of the 2-year rule. However, on appeal, OHA reversed and said that's inconsistent with the plain rule of the regulation. So it doesn't matter if the joint venture has received a contract award and nothing happened with that contract award, that award still counts for purposes of the 2-year rule. That also kind of goes in hand with, well, I was awarded an IDIQ contract, but I've never received a task order. That doesn't matter. The award of the IDIQ contract to the joint venture is the first award. So you do want to be mindful of that for purposes of the joint venture 2-year rule. This hub zone appeal just doubles down on what I said earlier in terms of not relying on payroll records, in terms of establishing who is an employee. You need to be able to provide sufficient work product for whatever individuals you're claiming as an employee. On the 180-day rule that I just discussed, this case, the last one on the screen explains that you're focusing on the date of initial offer, including price, not any subsequent offer. And then next, I'm going to touch on the 8A program, which may not be applicable to everyone, but I know that this is a very hot topic right now. So something that did go into effect in 2025, which may seem a little minuscule, but is important to reiterate, is the bona fide place of business requirement has been reinstated. So if you are an 8A construction firm, any 8A construction contract requires you to have a bona fide place of business. That went back into effect October 1st. However, there was a press release from Senator Sullivan's office on December 10th that announced that he reached an agreement with SBA that businesses will have 60 days after contract award to meet any location requirement. This is not anywhere that I can find confirmed by SBA. SBA's regulations still talk about having the bona fide place of business before bidding, or you have to go through at least that process before bidding. So if you are in the 8A construction world, you still want to be complying with this requirement unless and until there's further guidance from SBA, which supposedly is forthcoming. Obviously, there's a lot of changes to the 8A program, most recently at the end of 25 and now into 2026 regarding the audit or data call, whatever you want to call it. So the audit was originally announced in June. It was supposed to be led by SBA's Office of General Contracting and Business Development and supposed to start with high dollar value limited competition contracts. Well, December 5th rolls around and SBA, through the Office of General Counsel, issued a formal data call to all active 8A companies. Didn't matter if you never received a contract. Anyone that was 8A as of December 5th should have received the data call. It was intended to identify waste, fraud, and abuse in the 8A program, and the submissions were all due on January 19th, largely focused on financial and contractual data. SBA issued a news release last week, January 22nd, explaining, amongst a number of other things, that only 65 firms were admitted to the 8A program in 2025. That, I mean, is a significantly low number, but apparently SBA also issued guidance the same day discussing kind of why they have pumps the brakes a little bit on the 8A application regarding the social disadvantage requirement largely. This guidance states that no American shall be excluded or treated differently based on race for the 8A program. So SBA is working on finalizing regulations and program guidelines in terms of how 8A applications are going to be processed going forward. So that kind of gives a little bit of insight into why there were so few companies admitted in 2025. Also in this news release, it did confirm that SBA suspended over 1,000 companies from the 8A program as a result of the data call. I'm hearing that more could potentially be coming, so stay tuned. In addition to this 8A audit, there are more audits coming as well. GSA, DOT, DOD. On the DOD side of things, I know that they've announced an audit on any small business contract over 20 million. So that will be coming very, very soon. And I think I just have one more quick slide. So bear with me, I'll go about 1 minute over. So on FAR Part 19, this used to be referred to as the small business programs. This is now through the rewrite, just referred to small business. So a couple notable points from this, the rule of two, so meaning they have a contracting officer should set aside a contract or order for small businesses was largely maintained, but certainly modified. Contracting officers are no longer required to prioritize hub zone, SCVOSB, 8A, women-owned above general small business. However, contracting officers do retain discretion to choose which kind of socioeconomic status that they would like. Whether or not you want to protest that, Eric might be able to get into in his section. Another notable part of the changes to FAR Part 19 is that if there's an 8A contract, generally the rule is once 8A, always 8A. However, through this rewrite, now follow-on contracts could be removed from the 8A program without SBA approval if it's going to another socioeconomic set-aside, hub zone, SCVOSB, WSB. FAR Part 19, as revised, does prioritize competition over sole sourcing, even for 8A. So you could be looking at a lot more competitive procurements. Another thing is that recertification is supposed to be limited to a contract level, not the individual order level. However, a lot of what's in the FAR Part 19 rewrite conflicts or arguably conflicts with SBA's regulations. Generally speaking, things that are within SBA's purview, i.e. size, status, generally you defer to SBA's regulations, but there's going to be probably a lot of litigation and dispute and protests regarding this. So with that, I'm going to turn it over to Eric.
Thanks, Megan, and thank you all for joining us again this afternoon. So I'm going to talk about bid protests, and no better way to transition into this than Megan's last bullet point, file protests. 2025 was a significant, important year in the world of bid protests. And for anyone who's not familiar, a bid protest is a challenge by a contractor to the government's actions during a procurement. Protests are an important mechanism that Congress created, and they ensure that the government is complying with laws when spending public money. Unlike previous years, though, 2025 was significant, kind of less so as a result of the protest decisions that came out of the GAO and the Court of Federal Claims, the two main forums that handle protests, and more so as a result of the focus on bid protests from the government, from Congress and the administration. So what we're talking about here is bid protests in 2025, and what we saw were fewer protests, fewer rules surrounding bid protests, and a desire for less oversight on the bid protest process. All of that kind of leads to an increased importance of protests in 2026 and moving forward to ensure that the government is following those rules and that you as a contractor aren't sort of held to the whims of the government when making these important procurement decisions and when investing a lot of your time and resources into preparing your proposals. And so with that, Kaylee, we can move on to the next slide. So we're going to start with the numbers here. We always like to start with the data. And overall, in 2025, the number of new bid protests that were filed went down pretty significantly from previous years. 2023, we always think of as a sort of high watermark for bid protests, and there were 2,194 protests filed that year between the GAO and the Court of Federal Claims. Now, just 2 years later, we have 272 fewer cases that were filed. That's about a 12% decrease in the overall number of bid protests between those two forums. Those overall decreases don't tell the full story, though, because between the two forums, GAO and the Court of Federal Claims, we're seeing this continuing trend playing out where more protesters are choosing to go to the Court of Federal Claims in the first instance than we really ever saw before. The 234 new protests filed in the court last year are about a 38% increase in filings at that forum since 2023. And so we're starting to see that GAO used to be the forum of choice for protesters. It still is to some extent due to the automatic stay provisions, their exclusive jurisdiction over task order protests, and their relatively quick 100-day turnaround time for issuing decisions on protests. But we're seeing more protesters now go to the court, which presents its own advantages in terms of a more fulsome record, a more rigorous review, and more advantageous case law on certain issues. I would say, too, that the number of protests filed at the Court of Federal Claims isn't exactly indicative of the total number of protesters going there in the first instance. A lot of cases are settled between the protester, the Department of Justice, and the agency prior to there ever being a complaint filed. So that number at the Court of Federal Claims may actually be inflated somewhat by those protests that were settled with corrective action before a complaint was ever filed. Kayla, we can move on here. It wouldn't be a year in review if we didn't talk about the decisions of 2025, and there were a few significant decisions out there. So we're going to start by going through some of those on this slide. And I want to start with the case of Da Vinci Company versus the United States, where the Court of Federal Claims ruling overturned some long-held beliefs about the applicability of the Buy American Act and the Trade Agreements Act. So in Da Vinci, the VA sought to procure a prostate treatment drug under a small business set-aside solicitation that was governed by the Buy American Act. The VA, when they were doing their market research, they found that there were no domestic small business manufacturers, and they secured a waiver of the non-manufacturer rule, which allowed resellers of foreign-made drugs to compete for this procurement. Da Vinci offered to provide a drug from Spain, and Spain is a TAA, the Trade Agreements Act designated country. Well, all of the other offers in this procurement offered to provide their drug from India, a non-TAA designated country. The VA ended up awarding the contract to one of those other companies, providing the drug from India, and then they secured a Buy American Act non-availability waiver premised on a somewhat inaccurate statement that all of the offers had offered drugs made in India. That led Da Vinci to protest, challenging that the VA failed to apply the TAA to this procurement. The government in this case defended, and they basically claimed that once an agency categorizes its procurement as a small business set-aside, the BAA, not the TAA, applies, and nothing that occurs afterwards, i.e. this non-availability waiver or non-availability of sources, will change that determination. BAA applies, not the TAA. And the Court of Federal Claims went through a pretty fulsome decision analyzing the interplay between these two laws and rejected the government's argument. According to the court, the TAA applies to all procurements, except for when a BAA domestic preference is invoked. But once an agency waives that BAA preference through a non-availability waiver, the TAA's obligations then reassert themselves onto that procurement, and the agency must procure from a TAA designated country. So this is an important case for any suppliers of foreign-made products going forward that you're not out of the woods just because it is a BAA, small business set-aside. The TAA can come into play, and it may actually make the difference between you getting an award or not receiving an award, like it did in the Da Vinci case. I'm going to move on to the percipient AI case, and this has been one of the most discussed government contracts cases of the past few years. It's been a pretty long-running saga at the Court of Federal Claims, the Federal Circuit, with briefing all the way up to the Supreme Court. And it finally ended this year in what I'd call a somewhat frustrating decision for small businesses and subcontractors alike who are seeking to enforce their rights under some of these statutes. So the Court of Federal Claims has jurisdiction to hear bid protests alleging that there's been a violation of a procurement law in connection with a procurement. That seems like pretty broad jurisdiction because a procurement goes all the way from the requirements development phase through to contract closeout, and any violation of law in connection with that procurement could arguably give the court jurisdiction. There's a statute at play in this case that invokes the government's preference for commercial items. The government loves to procure commercial items, and that statute requires prime contractors and subcontractors at all levels to incorporate, to the maximum extent practicable, commercial items as components of any items supplied to the government. Percipient AI had a commercial software application that would be incorporated into this system that the prime contractor was going to deliver to the government. But Percipient didn't compete for that prime contract award because it didn't have the resources to compile that entire system. It just wanted to sell its commercial software to the prime to be incorporated into that system. So it proposed its commercial software to the prime contractor, but the prime unfortunately rejected that offer, kind of choosing to develop the software on its own instead of using this commercial software that existed. Percipient then went to the agency. They requested the agency enforce the statute, and the agency rejected that request. So Percipient protested at the Court of Federal Claims. Now, the court and the Federal Circuit, they didn't even really get into the merits here because the Court of Federal Claims found quite reasonably that Percipient was an interested party to challenge the agency's failure to accommodate commercial items to comply with this statute. The Federal Circuit initially agreed with that ruling on Percipient's standing to make this challenge, but then the government and the intervener requested a full review from the entire Federal Circuit. They call that an en banc review, where all of the judges at the Federal Circuit get together and decide the case. And this year, the majority of the Federal Circuit went back to its long-standing interested party rule and said that only those companies that were actual or prospective bidders for the prime contract have standing to challenge the government's procurement actions. Percipient tried to get the Supreme Court to weigh in on this, and the Supreme Court just recently rejected that bid. They're not going to hear the case, leaving this Federal Circuit decision as kind of the final word here. And that decision leaves commercial suppliers, many of whom may be small businesses, without any effective recourse for violations of these types of statutes that give subcontractors certain rights. It also signals to prime contractors that these statutory requirements will not be enforced or will not be enforced by a court in a bid protest. And it is a disappointing, somewhat frustrating decision for Percipient and anyone that finds themselves in similar shoes there. The final case of the year actually has not been decided, but it is important and has implications moving forward. That's Life Science Logistics. And so Life Science Logistics filed a timely GAO protest that triggered the automatic stay of performance that you get at GAO with that protest. GSA then decided to override the stay, and Life Science challenged that override decision at the Court of Federal Claims, where the Court of Federal Claims ruled that the override decision lacked a rational basis. So the stay is in place. This year, the government decided to appeal that ruling, and has gone to the federal circuit with arguments just concluding this month or this past month, December, arguing that it's not enough to reinstate the stay once you find that the override decision was irrational, that the court also needs to consider the injunctive relief factors, irreparable harm, balance of harms, and the public interest. The Federal Circuit seemed to express some doubts about the government's position at argument, but if the Federal Circuit rules for the government, it's going to essentially flip the automatic stay provisions at GAO on their head, making that process more like seeking a preliminary injunction at the Court of Federal Claims and potentially leading more protesters to the court. Kaylee, we can move to the next slide now. It wouldn't be a discussion of 2025 without discussing AI. And the big takeaway from this year in terms of AI is that the AI tools are just not there when it comes to bid protests. AI hallucinates cases, meaning that it makes up cases that don't exist. It also hallucinates holdings from cases, meaning that it provides a real case citation, but that case doesn't actually stand for what the AI claims it stands for. These issues have come up at GAO and the Court of Federal Claims in both the bid protest and other contexts. And what we're seeing is that GAO and the court are not taking kindly to these AI hallucinations in briefings, threatening sanctions, dismissal of the protests, and more. So the long story short here is, if you're talking about a bid protest, don't rely on AI. It's going to lead to bad results for you if you file protests. It's going to lead to increased cost and resources if you're kind of presenting these AI cases to your attorney. Kaylee, I think with that, we can get on to the next slide here. So the FAR overhaul, again, occurred this year. These FAR overhauls haven't taken effect for all agencies. Some agencies have issued class deviations, but the FAR overhaul stands to have a large impact on protests moving forward. And Kaylee, I think we can jump forward here. The most significant part of the FAR, I think, in terms of most government procurements is FAR Part 15. It deals with the government's most complex and, important acquisitions and provides the rules here. So the rewrite with respect to 15 is especially important in terms of going after government procurement and potential protests. One of the biggest issues that we've seen in protests since really the beginning of protest time has dealt with the dichotomy between clarifications and discussions. And it's led to some splits between the GAO and the Court of Federal Claims in this way. And so the FAR 15 rewrite appears to address those splits. The first part of this has to do with clarifications. The FAR previously used this term that really rolls off the tongue, communications with offers before the establishment of the competitive range. That term has been replaced by the term clarifications. And the overhauled portion of FAR Part 15 now provides that clarifications are expressly discretionary and they do not need to be conducted with any other offer if the agency decides to engage in clarifications with one. So for a long time, the GAO has held that there is no obligation for agencies to conduct clarifications, and it really will not hear cases that the agency improperly did not conduct clarifications. Whereas the court has held an agency can abuse its discretion by not engaging in clarifications with an offer. This rewrite appears to be taking the GAO side of that, but it remains to be seen whether the COFC will still apply its case law in deciding these cases going forward. And I think this rewrite really suggests that if you have a clarifications issue, GAO is not the right place to go for you. You should be headed to the Court of Federal Claims until the case law says otherwise. Talking about discussions, the term discussions has now been replaced with negotiations, and negotiations are different from discussions in a few important ways, including that there's no requirement to address adverse past performance. That's now a part of discretionary clarifications. And there can be further negotiations with an offer without obligating an agency to have negotiations with others. So You may need to conduct negotiations with all at the outset, but one offer can get additional discussions without the need to open those back up to everyone. Again, we'll see how this affects the case law going forward on a lack of meaningful discussions or unequal discussions, but the rewrite appears to give the agencies a lot of discretion in this regard. I know we're getting close to time, so I'm going to move a little quickly through this. Two new source selection procedures are outlined now in the new overhauled FAR Part 15, highest technically rated with a fair and reasonable price, and phased acquisitions. We've seen these before, but their presence in the FAR might lead to increased use and maybe increased protests over whether the agency is using those procedures appropriately. And I think one of the biggest changes for protests comes with debriefings. The overhaul is largely the same when it comes to debriefings, although it's reorganized. But now the new FAR Part 15 contemplates the submission of follow-on questions, similar to what we've been dealing with DOD enhanced debriefings for some time. The caveat here is that this new regulation says COs may provide this opportunity if time permits, and it notes that these questions and answers occur after the post-award debriefing, leaving one to really guess whether that debriefing will remain open until you get the answers like you do in the DoD setting. Best rule is to play it safe in this time. Kaylee, I think we can jump to the next slide now, and I'll move quickly here. So FAR Part 33 deals with protest, and there's a new purpose of the bid protest system. It's largely consistent with what we generally understood the purpose of the protest system to be, with two important carve-outs here: one, to deterrage and discourage abuse of the bid protest process, and the other to minimize disruption to contract and award and performance. Those seem to be administration additions to this. The administration has not made it a secret that it does not like the bid protest process. And we'll see if under this new guidance, we get more overrides of SECA stays, as well as more requests for dismissal. There is an important part to FAR Part 33 on agency level protests that I want to call everyone's attention to, which is that if you file an agency level protest and request a review above the CO, you now have the ability to get the redacted source selection decision document. And so that may be one incentive of going for an agency level protest if you don't have a lot of information to go on. Kaylee, we can move on here. I'll quickly touch on the bid protest reform. And so, like I said before, the agency hasn't, or the administration has, made no secret about this, that it doesn't like the bid protest process as it currently stands. In 2025, Congress asked GAO to propose a fee shifting process to help recoup costs from frivolous bid protests. And GAO responded basically telling Congress it can't develop those benchmarks. It doesn't have the data, but it doesn't think that this is really a problem because the statutes and regulations already help resolve frivolous bid protests quickly. In 2026 NDAA, Congress responded, including a provision directing DOD to establish these procedures where the agency can withhold up to 5% in payment to any incumbent if that protest is dismissed for lacking a reasonable or factual basis. So that may lead to increased claims in the future, and we'll see if that has the deterrent effect the DoD wants it to have. With Kaylee, I think we can go to the final slide now. So looking ahead to 2026, I would just say protests are going to always continue to play an important role in government procurement. They're a natural part of the process. And with the reduced rules in the FAR overhaul, the asks for less oversight through the protest process, I think protests are actually going to play an even more important role in helping contractors and the public protect their interest in fair, lawful procurements. There's going to be an increased emphasis on consolidation of procurements as well, which makes each procurement more valuable and each protest that more, incentivized for contractors to file those. And with that, I will turn this over to Lauren. Thank you all for your time.
Great. Thank you, Eric, for all of that. Really appreciate it and very informative. So I am going to talk about REAs, claims and appeals, and big issues that were hot topics in 2025. But the biggest one probably coming out of 2025 in our area of practice was really the lengthy shutdown that we experienced. And given the fact that we're facing another impending partial shutdown, I felt it was relevant to cover this topic at the forefront. So we moved it to the front. And I just want to remind everybody that this is really more so a partial shutdown. So the affected agencies include DHS, Defense, Education, HHS, HUD, Transportation, State, Labor, and Treasury, and some others. So just something to keep in mind as we get past Friday and see what's going on. But just some big tips that we took away from 2025 is first one, understanding the consequences. So a shutdown can result in delays to contract awards, payments, and approvals. So what I've been recommending to our client base is really doing an internal audit between now and tomorrow, really seeing how certain contracts can be impacted, areas in which invoices are pending, or any particular RFI or RFP is pending for contracting officer approval, taking that into account so that you are prepared as of Monday of next week. I'm addressing outstanding issues early. So this feeds into what I just said about, taking a look at, do you have deliverables that are potentially due next week? How does that impact you moving forward? Are you communicating with your contracting officer? Are you waiting on a very important modification? Taking a look closer at those issues and making sure that you're opening lines of communication with your contracting officer so that you understand the impact that the shutdown can have. Another point, knowing your obligations. So this is extremely important, is taking a closer look at your contract for clauses that relate to a potential suspension of work or even a stop work order, and understanding what those clauses entail. So an example of this is we had clients reaching out that had received stop work orders and they have a commercial items contract. If there is a change to a commercial items contract, that requires bilateral agreement. And so typically those contracts do not have stop work clauses in them. That clause is 52.242-15. So we suggest to clients that you take a look, review your contract, understand your rights. It could potentially create some leverage if the government is trying to stop work under a particular clause, and it could potentially entitle you to recovery of costs. So again, taking a closer look at your contracts to understand what clauses are in there and as they pertain to the shutdown. Another big practice point, communicating with your COs and your subcontractors. If you feel like the shutdown is going to be impacting a particular project or program, making sure that you understand the directions from your CO and the directions that you then would want to pass along to your subs. So taking a closer look at that is also extremely important. And then my biggest point is document everything. Make sure that you're getting things in writing. If you are calling your contracting officer about something and they're giving you a particular directive, make sure you follow up with your contracting officer via email so you have a written record of that communication. We don't want to be relying on any verbal directives or orders. So again, really important that you're keeping records of any notices or directives that you're getting from the contracting officer. And then on the flip of that, any costs that are incurred. So under the stop work clause, you are entitled to adjustment costs associated with that stop work directive. So if you have to demobilize, if you are on standby, if you have personnel that are on the bench and you're incurring costs as a result of the shutdown, tracking those costs contemporaneously is extremely important, because if you do want to seek those costs through a request for equitable adjustment, you want to have those detailed records and the evidence to support the costs that you are requesting. Otherwise, it may get denied by the contracting officer once submitted. So Kaylee, we can go to the next slide. So some impacts from the contract administration side, how this plays into the disputes process. So these are some more detailed points to provide. So understanding your stop work order rights. So you have 30 days for adjustment from the time the stoppage is lifted. So something to keep in mind, we've had some clients reach out on the last shutdown, and we've had to explain to them that you have 30 days to submit that adjustment or to provide notice to the contracting officer and seek an extension. So really important that you understand your rights, you understand the timeline and how long this shutdown may potentially last, because that could potentially prohibit you from seeking any type of cost recovery if you find yourself outside that timeline for a request. understanding pending invoices, termination settlement proposals, which the acronym is TSP, REAs, and claims. So if you have an outstanding invoice, a termination settlement proposal, an REA, or a claim, realistically, you have to think through, well, if there's a shutdown, there's no contracting officer to respond to this. So just taking that into account, that all of those submissions could potentially be delayed. If the shutdown surpasses the 60-day CO deadline, so say you submit a claim, prior to the shutdown, under the FAR, the contracting officer has 60 days to respond to that claim. But with the shutdown in place, this contracting officer is likely going to ask for an extension to respond to that claim, and it would likely be granted if you were to challenge that request. So again, just keeping that in mind, that it is likely going to delay any response on a claim, an REA, termination settlement proposal, or an invoice. If you have a pending appeal at the Armed Services Board or the CBCA, those matters will remain open, and both of those boards are capable of receiving filings, CBCA through the electronic docketing system and the ASBCA via their email. One of the things that did happen during the shutdown is that the ASBCA did suspend, the last shutdown was the ASBCA did suspend certain deadlines, and the CBCA did cancel some hearings, mediations, and conferences. So if you have pending appeals, keep that in mind. It could potentially impact your ability to proceed in that appeal, and it could delay some of the schedule. One thing to note is that during the 2025 shutdown, that COFC did remain open. We are hopeful that that will continue through this partial shutdown. So something to keep an eye on. And then for new disputes, this is another big pointer. The statute of limitations on a certified claim under the Contracts Disputes Act is 6 years. A shutdown does not toll that timeline. So if you have a claim and the issue arose, 6 years ago, you need to get that claim out the door. Otherwise, you risk being outside of the statute of limitations and it being rejected. So very important to understand your rights, any potential claims that you may have, because just the fact that there's a shutdown doesn't mean that your claim is tolled. So even if there isn't a contracting officer available and they are furloughed, still get that claim out the door, get it submitted via email to the contracting officer so that you can preserve your rights to those costs. Otherwise, you could potentially be untimely. Another thing too is it is critical to submit your invoices and termination settlement proposals, REAs, and claims. The same thing applies. Deadlines are not tolled as a result of the shutdown. So big reminder, we had, a good amount of contractors receive terminations in January and February of 2025 due to the change in administration, meaning your termination settlement proposal may be due within these upcoming months because you typically have a year to submit those. So, just because there's a shutdown in place, your submission of that termination settlement proposal is not tolled. So being mindful of those deadlines is extremely important. So we can go to the next slide, Kaylee. So jumping to the Board of Contract Appeals annual report. So just like GAO, both the CBCA and ASBCA put out a 2025 report, which basically runs through the amount of cases that were docketed, how those turned out. And the interesting point is that at the CBCA, there were more cases docketed this year than last. And that there were more appeals in ADR in 2025, which is interesting because really both of these boards very much encourage alternative dispute resolution. And from my perspective, what we have seen in the last year is that the administration as a whole has been less likely to encourage their agency reps to engage in ADR. One of the reasons being, I think, is that they are being told to only agree to make payments on a particular claim if a judge actually orders them to do so. So I do think that that may be driving some of the reason why ADR has decreased at both boards over the last year. One thing to note is that there was an influx in disputes involving the VA. 70 of the 222 disputes that were heard by the CBCA last year were VA-related disputes. So something to keep in mind there as well. We also can expect an increase in the EDS functionality. So one of the big things that was rolled out at the CBCA in 2025 was their electronic docketing system. It's similar to GAO's docketing system where you can formally file online and it basically maintains it in an online docketing system. So they are expanding that functionality, which is a great thing for us as lawyers, but also for pro se litigants. And then one of the things that the CBCA has also mentioned in recent reports is the use of AI and the associated risks. And this kind of feeds into what Eric was talking about, that if you are using AI, making sure that you are double, triple checking the citations that you're using, where you are getting that content, because things are getting kicked out rather easily at CBCA, particularly by pro se litigants that are using AI to draft claims and appeals. At the ASBCA, there was a decrease, again, like I said previously, in use of ADR procedures, which is unfortunate. There's 28% of cases involved the Army Corps of Engineers, which was the largest group at the ASBCA. And then, again, ADR was less popular, only used in 80 cases at the board this past year. So we can go to the next slide. So one positive to come out of the report, which is a big one, is the notable successes for contractors that go all the way to hearing or to briefing. Both of these forums, the ASBCA and the CBCA, are favorable forums for contractors. 67% of appeals taken on the merits at the ASBCA were successes for contractors, which is huge. And then same thing with CBCA. 61% of the appeals that took it to the merits this year, which means all the way through hearing or briefing, were successful on behalf of the contractors. That doesn't mean that they receive full merit, but even partial merit is something. And so, both of these forums serve well for contractors, so it's absolutely something to take into account when you're considering whether to file a claim or even appeal a contracting officer's final decision that may not be favorable. So we can go to the next slide. So just some practice reminders when you're trying to decide between using the Board of Contract Appeals or going to the Court of Federal Claims, that plays into what we're seeing from 2025 is that we believe that the Board of Contract Appeals is often just a more efficient process for running through your claim under the CDA, that you could have a better ability to mitigate costs, and the timeline associated with federal litigation can be extensive at Court of Federal Claims and is more likely to be short-circuited at the Board of Contract Appeals. Oftentimes, disputes at the Board of Contract Appeals can be less adversarial. You're dealing with just an agency representative of their counsel versus dealing with DOJ and the agency representative. Typically, I would say you're more likely to engage in ADR at the Board of Contract Appeals versus the Court of Federal Claims, which I do think is still the case. The reason being is that if you file an appeal with the Court of Federal Claims, DOJ typically does not consider ADR processes until you've gone through full discovery. At the Board of Contract Appeals, agency reps are typically more inclined to engage in ADR earlier on in the process, which is a benefit particularly to small business contractors because it does provide an ability to keep costs down. We also feel like the judges at the board, oh, sorry, can you go back real quick? We also feel like the judges have a little bit more federal contracting experience and experience with the FAR. At the Board of Contract Appeals, a lot of the ALJs that sit on both of these boards have federal contracting backgrounds, whether they were in the federal contracting space on the agency side or in private practice, where you're going to COFSI. Some of the judges have, more patent-focused backgrounds, less federal contracting backgrounds. So again, the judges we feel at the BCA may have a little bit more expertise in these types of disputes. And again, like I said on the ADR piece, agency attorneys may be more likely to consider settlement earlier in the dispute process, where DOJ at COFSI typically likes to go through discovery, which can be lengthy, costly, and extensive. So just something to keep in mind when you're filing an appeal and you're deciding between which forum to select. So we can go to the next slide. So another big takeaway from 2025 is, since the change in administration and with DOGE coming into play, there was a massive influx of stop work orders, de-scopes, and terminations for convenience. We fielded so many stop work REAs. We submitted hundreds of termination settlement proposals, it seems, over the last year. I'm just trying to get people recovery. And a lot of that, again, was initiated by DOGE and just more of these efficiency-related directives coming out of the Trump administration. What resulted from these government-wide contract reviews and increased scrutiny, again, were stop works and reevaluations of particular contracts and programs, and often resulted in termination of contract work for convenience. In the event of you receiving a stop work order or some form of descope or termination for convenience, the big takeaway is focusing on the documentation that you have for any type of cost recovery under these 3 issues. The government does have broad discretion to issue these, so challenging them, like the actual decision to issue a stop work, a descope, or a termination is often quite challenging. But cost recovery, there are FAR regulations in place to allow for that, so just something to keep in mind, and I'll get into those in a little bit more detail. So we can go to the next slide. So talking about stop work orders and terminations for convenience. So stop work order, like I said, the FAR reference, if you want to take a look at it, is 52.242-15, but it may be issued at any time by a contracting officer's written order. It's not to exceed 90 days, but the contracting officer can terminate at any time. Contractors are required to mitigate their costs associated with a termination for convenience. So if you do receive a termination for convenience, you have to immediately notify your subcontractors. The same thing with the stop work order, notifying your subs that you have to stop work and really working with your team internally to determine how best to mitigate your costs. And then, like I said earlier, that 30-day requirement to get your request for equitable adjustment out the door if you can sufficiently support stop work related costs, whether that's demobilization or putting personnel on standby, for instance. The CO is required to make an adjustment if sufficiently proven. So something to keep in mind if you're dealing with a stop work during the shutdown or even outside of the shutdown. For terminations for convenience, again, government may terminate the contract for its convenience when it's in their best interest. The contractor is similarly required to stop work. After the termination for convenience, typically the contractor and the government will settle those remaining costs. One of the things that we are seeking, just a practical example, one of the things we are seeing is that a lot of contractors are getting stop work orders while the government was reevaluating the funding or the program itself. And then once that stop work order was rolled out, weeks or months later, that client similarly received a termination for convenience. We had a lot of clients asking us, like, what do we do with all these costs? They're a little bit different in nature. And my suggestion is that those get rolled, so your stop work costs do get rolled into your termination for convenience proposal, but you do have to make sure that they're broken out appropriately so that when you're submitting that to your contracting officer, they really understand, okay, these are stop work costs that they go in one bucket, and then your termination for convenience related costs go in another. And those all can be negotiated and resolved at the termination for convenience phase. So just something to keep in mind. We can go to the next slide. Okay, so descope modifications. So this is another very popular thing that we've been seeing in 2025. And it's basically exactly what it says, descope portions of a particular contract. So big point is to determine whether your contract requires bilateral agreement to change the scope of work. Like I said before, taking a look at commercial items, bilateral agreements are required for such a change in scope or descope. So something to keep in mind that can create some leverage for you if you're in negotiations with a contracting officer over such a change. It's really important that you evaluate the cost and time impact of the descope. We saw a lot in 2025 where contracting officers were either really pushing for a credit from certain contractors as a result of a descope. And a good reminder is that a credit isn't always an outcome of a descope. Sometimes a descope results in actually extra costs for a contractor. So making sure that you understand your rights, that you're just not conceding and agreeing to a credit is really, really important. Especially if it's issued unilaterally and you're not in alignment or agreement with how that descope was issued. Very important to keep that in mind and making sure you reserve your rights to submit an REA or a claim. So we can go to the next slide. So I think I'm going to shift gears now and just talk about some big cases that came out of 2025 they're also relevant to some of the talking points that I shared previously. And one of them being the reinstatement request hitting a dead end. So in Texas Industrial Security, Inc., and this was a big question that we were getting from contractors that were extremely upset, particularly last January and February with the change in administration. All of a sudden, they were getting multiple terminations for convenience, and they felt like those terminations were being done in bad faith. and mostly driven by DOGE. So they, we were fielding a lot of calls. I want my contract back. And that is just not a reasonable outcome when a termination for convenience is issued. Not only because it typically can be issued when it's in the government's best interest, but also because under the CDA, the Board of Contract Appeals, which is the ASPCA, CBCA, and the others, in the Court of Federal Claims do not have jurisdiction or authority to issue injunctive relief. So when you challenge a termination for convenience, the outcome there, the relief, is you are entitled to costs, but you will not, it's very unlikely that you will get your contract back because the Board of Contract Appeals and the Court of Federal Claims cannot direct performance. So they can't say, hey, agency, you need to give the contractor's contract back. They cannot issue such relief. And this case basically reasserted that notion that the board cannot reinstate a contract terminated for convenience. And really the only instance where that can happen, which is extremely challenging to demonstrate, is if you can show bad faith, which is a very high burden and very hard to show. So just something to keep in mind, that if you do get terminated for convenience, the likelihood of reinstatement is extremely low, and just understanding the outcomes there. And then we can go to the next slide. So in Silsco, this was another big case that came out in 2025 that dealt with CPARS appeals. So in this case, the contractor challenged an unfavorable CPARS, saying in part that the CPAR was too late. So typically it's 120 days for a CPAR to be issued from close of performance or close of the evaluation period. But in this case, it was a lot of days outside of that 120-day window. So that was one of their main arguments, that the CPAR was too late. What the Court of Federal Claims said here was that if you are arguing that a CPAR is too late, you can't just say, well, hey, they're in breach because they're outside of this 120-day window. What a contractor is also required to show is that the late issuance of the CPAR actually caused you significant concrete harm. So you actually have to demonstrate that the damages that resulted from this delayed CPARs, and in Silsco, they were not able to demonstrate that to the court. So that is a big takeaway. Another big point is that FAR 42.15 isn't automatically incorporated into every contract, which requires the issuance of a CPAR. So, making sure that you review your solicitations and award documents closely to understand if a CPAR is even necessary and required, so that may give you an ability to push back on any CPAR evaluation that may be unfavorable. Another thing too, as far as the burden on the government to demonstrate accurate CPAR, is that to challenge that, you have to show that there was an abuse of discretion. So basically that the ratings were subjective, and to demonstrate that, you have to very much build a factual record that counters any statements that are made by the contracting officer. So really important that if you're working on a project and you start to see it going south a bit, that you are contemporaneously recording communications that you're having with the contracting officer, with your subs, et cetera, so that if you do find yourself on the an unfavorable side of the CPARS rating, you have the evidence to then combat that and show that the evaluation in and of itself was subjective, and that they did abuse their discretion in evaluating you the way that they did. Another takeaway from this case is that they argued that the government had breached their duty of good faith and fair dealing, and basically the court said that there's limits to that type of argument, and that you actually have to anchor such a claim to clearly stated contractual language. So you actually have to show that the government was in breach of a particular term and condition in your contract to show that they also breached their good faith and fair dealing. So another big point, just that boundaries were further defined on CPARS disputes in 2025. So we can go to the next case. So Beacon Point's another big case that came out of 2025. It was against the VA, and the Court of Appeals for the Federal Circuit examined whether the contractor's quote, including its terms and conditions, was incorporated by reference into the contract, and the court basically found in favor of the VA. And what they said was that although the quote was cited generally in the award, the contract itself lacked specific language incorporating Beacon's terms. So Beacon argued that the quote was referenced, and that they then tried to bring in some extrinsic evidence to say, like, both parties understood that this is how this program was going to go. But the court came back and said, well, the quote's provisions conflicted with the FAR, so they needed something more explicit in that contract to support Beacon's arguments, and the contract was devoid of that. So a big takeaway from this case is making sure that you use explicit language to ensure that your prime contract explicitly is adopting certain terms and conditions from your quote. So it's not enough that there's a general reference to whatever your quote says, especially if there's some conflict in that contract under the FAR, that you make sure that certain language is in that contract award before you move forward. So again, just a big practice point there. And then we can go to the next slide. Oh, okay, that is it for me. John, I will pass the baton over to you.
All right, thanks, Lauren, and thanks to Megan and Eric also. I think you all can tell how much knowledge and expertise they have with small business programs and bid protests and REAs, claims and appeals. So don't hesitate to reach out to any of them directly if you've got questions in those areas or questions about things they talked about today. I'm going to bring us home here. We're rounding third base. Thank you so much for everybody who's stuck it out, or if you're coming back after dipping out for a bit. Just a grab bag here. Let's go to the next slide and dive right in. CMMC is finally here. I mean, I think I've been talking about CMMC since I had a full head of hair, and it is finally here. There was a while there where it seemed like it was never going to get here. But late last year, the clauses went into the DFARS in November 10, 2025. So they now exist. They can go into new DoD contracts. They could potentially be modified and added into existing contracts. And I made the point here that if an agency tries to modify your contract to add CMMC, that should be done by a bilateral modification. I'm not sure you're going to be able to negotiate a cost impact, but at least I would think a time impact if you're not currently ready for whatever type of CMMC they're planning to put into your contract. So just watch out for that if an agency tries to mod your existing contract. And, the bottom line here is a significant one, because when this clause goes into a contract that you are pursuing, or that you already have, you're not eligible for award, or you're not eligible for options if you don't have whatever level of CMMC the contract requires. So let's go to the next slide. Just because these clauses are now in the DFARS doesn't necessarily mean that you all are facing this impact. I don't know if we were all in person together, I'd ask you to raise your hand how many of you have CMMC in your contracts already. I bet a few hands would go up because I've had clients reach out to me that are in that circumstance, but I think most contractors, it's still kind of a wait and see. Like, when is this going to go into the first solicitation that I'm going after? Or when's it going to be added to one of my contracts? And it's supposed to be phased in and rolled out over a few years. So depending on the type of work that you do, who your customers are, maybe you won't see this in the near term, but you could see it in a new solicitation tomorrow. I mean, I think that's the point. It's here. There is an exception for contracts that are purely for COTS items. So I know a good amount of our client base is in the world of either manufacturing or reselling COTS items. I don't know how much in the real world you'll be able to leverage that exception. I've heard some, I think they're just really anecdotes at this point, with customers not really wanting to hear it. Just saying, look, the CMMC requirement is in this contract. If you can't fulfill it, I'll just go to the next person in line. If Eric got a hold of that in a bid protest, it might be a different outcome. But just on sort of a practical day-to-day basis dealing with your customers, I've heard some people who I trust in the industry saying they're not sure how helpful that exception is going to be, because the customers just may not want to hear it, and they may insist that you have CMMC regardless. It needs to be flowed down to subcontractors based on the information that's being provided to the subcontractor. So this is a question we're getting a ton right now from subcontractors. They want to know, hey, my prime is telling me that I need CMMC level 2 with a certification. What do I do? And the answer is you may have to live with it, but you could have an argument to resist that if the nature of the information that the prime needs to give you for your performance of the subcontract doesn't require CMMC level 2. So, that's a conversation and a negotiation that needs to happen between primes and subs. And I know there's often an imbalance in the leverage there, but you shouldn't just reflexively accept whatever the prime is flowing down just because that's what the prime is subject to. The prime is supposed to be making an assessment of the appropriate level for the subcontract. And really, like all roads, CMMC, in my mind, lead to whether you have CUI in your system, controlled unclassified information. Are you getting that under the contract? Do you otherwise have it in your system? If you do, you're going to need CMMC level 2. There's just no way around that. And if you need CMMC level 2, again, I've a lot of people that I trust and know this space better than I do say you might as well go for the third-party certification. That may be kind of like the standard that a lot of your customers are looking to see that you have. So it is here. If you're not already preparing for for CMMC and you're a DOW contractor, make sure you have this on your radar for 2026, because I think this is going to be obviously a big issue in 2026. Let's go to the next slide. All right, FAR rewrites, everybody's favorite topics. My colleagues already talked about certain specific aspects of this. I just wanted to underscore that the FAR rewrites don't become official in the FAR until they do a public rulemaking. And once that rulemaking is done, then whatever is finally approved will go into the FAR. For now, agencies can adopt the FAR rewrite, but they have to issue a class deviation. And there's a website where if you're wondering whether your customer agency has adopted a certain part of the FAR rewrite, there's a website that you can look that up and see. And if you can ping me afterwards, I'm happy to share that link with you. I've heard rumors that the public rulemaking for the whole FAR rewrite is probably coming relatively soon, and they're going to have, the rumor is, a very short turnaround for public comments, which you probably could have some thoughts on why that would be. But if you are interested in submitting comments, and I think if you're affected by parts of the FAR rewrite, like for example, small businesses may potentially be affected by certain parts of the FAR rewrite that the perception is maybe are less favorable to small business, like the changes in the market research requirements in FAR Part 10 that are being, the viewpoint is that the changes are diminishing the role of small businesses in market research. If you want your voice heard on these changes, start preparing your comments now, because we know what the FAR rewrite proposals are. They're already out there. So it's just a question of when they're going into the Federal Register for a proposed rulemaking, and there probably won't be much time to write comments once they go into the Federal Register. So our recommendation is get cracking on that now if you're going to submit comments. Let's go to the next slide. I just wanted to touch briefly on a couple parts of the FAR rewrite that we haven't already mentioned. So Eric talked about how there's this push towards doing more commercial procurements, and I think that's not going away. That the consolidation towards GSA, emphasis on commercial procurements, so FAR Parts 8 and 12 are going to continue to be significant there, because FAR Part 8 is federal supply schedule, FAR Part 12 is commercial procurements. So just had some key highlights here. There have been some significant revisions to FAR Part 8. There's this term required use contracts for commercial products and services, and they're going to be mandatory unless an exception is granted. Now, my understanding is that the OFPP is supposed to be coming out with guidance on required use contracts. So I don't think we know right now what are the required use contracts, but I think that's something that we're anticipating the guidance to be out this year and have more clarity on. I think there's probably going to be an overlap between what you may be used to, the term best in class contracts. I think there's going to be an overlap between BICs and required use, but they're not the same thing. So just because something today is considered to be a BIC doesn't necessarily mean it's going to be considered a required use contract. BICs are not mandatory today, and under the proposed FAR rewrite, the required use contracts would be mandatory unless there's an exception. And I also noted that the simplified acquisition procedures for commercial product and service acquisitions gone up to 7.5 million. So again, this is just like make it easier for the government to go commercial, buy larger amounts of commercial products and services through simplified procedures. All right, let's go to the next slide. The OneGov strategy. If you're a reseller, if you're a small business reseller in particular, I think you're probably aware of this. I think this is going to continue to be a dominant theme in that market this year. You know, the GSA wants to go direct to manufacturers. They want to end run around the value-added resellers. We just put out a client alert earlier this week. GSA is asking for information from value-added resellers as GSA continues to implement this OneGov strategy. And I think it's really important that if you're a VAR, you need to have your voice heard. You know, they're asking things like, are all VARs simply pass-throughs? And I know from firsthand experience, many good clients of ours are VARs and provide a lot of value to the federal government beyond the products that they're distributing. So we need to dispel this notion that all VARs are simply pass-throughs. And so if you're a VAR, check out that client alert from earlier this week or ping me and make sure you get your voice heard on this. Next slide, please. Also, I wanted to mention this right-sizing initiative. Since we've got this push towards GSA, you know, they're becoming so important or even more important for procurements. They've had this right-sizing initiative since last year where they're being stricter about kicking companies off of the GSA schedule if they're not meeting their minimum sales requirements. I think we expect that's going to continue this year. You know, so if you're not meeting your minimum sales or you have other compliance-related issues on your schedule contract, you're going to be more at risk of losing your schedule contract, which is becoming even more important to have. So that just puts a focus on staying in compliance with your GSA schedule contract terms and conditions, even more important in 2026 than it's been in the past. Let's go to the next slide. All right, some highlights on the 2026 NDAA as we round into home here. So there were a lot of provisions that were aimed at increasing competition by small businesses and what they called non-traditional defense contractors. So I think, you know, as a general rule, that's favorable for small businesses. This Project Spectrum, you know, could help with things like CMMC that I talked about earlier. There's also more emphasis being placed on best value over lower cost. That's been a trend we've seen in several NDAAs for a little while now, you know, moving away from LPTA in favor of best value. I think Eric mentioned the potential penalty on bid protests that don't have a reasonable basis. So they're just concerned about incumbents protesting just for the sake of getting a few more months on the contract. So there is this drumbeat. Congress is definitely focused on bid protest reform. Let's go to the next slide. Several contract thresholds went up. The threshold for providing certified cost or pricing data is going to go up. The threshold for requiring higher level approval of sole source contracts is going to jump up significantly. Both of those, I think, take effect for contracts after the end of June this year. So, you know, it's going to be a lot easier for agencies to do larger sole source contracts. I think that's the takeaway of that second bullet point there. Notably absent from the NDAA, we thought there would be reauthorization of the SBIR and STTR programs. They've been lapsed since the last shutdown. And they didn't get reauthorized in the NDAA. I think one of our colleagues was at an event a few days ago, said that it seems there's optimism they will be reauthorized soon. I think there is a general sense that those programs are important and we want them to continue, but it's just hasn't happened yet. And there were some proposed significant changes to how CPAR's evaluations would work. So they would no longer be looking at what's favorable about what you did. They would just focus on significant negative elements, but that proposal didn't make it into the final NDAA. We'll see if they come back to that proposal in the future. So I know we are at time and you all have sat through a longer than usual webinar with a lot of information. I am going to continue to wrap up. I have about 3 slides left, but I completely understand if you need to go ahead and log off. But for those who can still stay on, or for that may be listening to the recording after the fact, I'll go through the rest of the slides here. So we started talking about this last November, like major initiative within DOW to transform their acquisitions. You know, they truly are bold plans. And just some highlights here of what this will mean. I don't think this is, you know, they are maybe literally and figuratively moving the battleship. So it's, you know, not going to happen overnight, but they're going to be pushing for greater IP rights. I thought that's notable. Even a further push towards non-FAR-based instruments like other transactions authority. We're doing a lot of work with OTAs. And so that has really taken off in 2025, and that's going to continue. So if you're not familiar with OTAs, or you have your first opportunity to work under an OTA, we have folks on the team that can help you with that, and please reach out. And there are some, you know, exemptions for what they call non-traditional defense contractors. I think the idea is to get these firms involved in government contracting, you know, benefit from what they can bring to the table. So the DOW wants to facilitate that by making it a little easier, you know, exempting from certain requirements like the cost principles and business systems requirements. So that's the idea there. Let's go on to the next slide. So new rules we're expecting this year. We've been tracking this in our GovCon group. Also, our M&A group runs into FOCI on transactions. FOCI stands for Foreign Ownership, Control, or Influence. This only applies if you have foreign ownership. So if you don't, you can check out for the remainder of this slide. But if you get bought in the future by a company that has foreign ownership, then you may have to contend with this. Right now, we don't have to worry about FOCI, I think, by and large, unless we've got classified contracts. But several years ago, the NDAA said, DOD at the time, now DOW, we want you to implement policies and procedures around vetting FOCI risks on unclassified contracts. And they just haven't come out with the rules yet. But last year, the DCSA forecasted that those rules would be out in 2026. So we're keeping an eye on this and what that will look like for unclassified procurements. So again, it won't directly apply to you if you do not have foreign ownership, but it could apply to a competitor of yours you may be pursuing an unclassified contract against, and you might start to see processes in solicitations possibly later this year for vetting risks associated with a contractor that has foreign ownership. Now let's go to the next slide. All right, the dawn of FASCA, the Federal Acquisition Supply Chain Security Act. I just wanted to wrap up and make sure that everybody was aware of this. It's relatively new. It's the latest in litany of restrictions over the last several years that have come out related to foreign entities that the US government does not want you working with. So you're probably familiar with the FAR clauses that have been around for a little while that pertain to certain Chinese manufacturers of telecommunications. So this new law has been implemented through the FAR clauses on your screen here. So if you have these FAR clauses in your contracts, then you're not allowed to be using products or services from a source that's prohibited by a FACSA order. And so those orders are going to be posted in SAM. There's only one of them that I'm aware of right now. It was posted in September about this Swiss company called Acronis. But if you're subject to these clauses, you're supposed to be checking SAM every 90 days to see if there's a new order. And then if there is, you need to perform a reasonable inquiry of your supply chain to make sure they're not in your supply chain. So it's just, again, more emphasis on supply chain security and risks associated with certain entities that may be in your supply chain. All right, if we go to the next slide, I believe that is all of our contact information. That is all the content we had for you here today. Again, thank you very much for taking this trip down memory lane in 2025. As painful as it may have been in some respects, and looking ahead to 2026. Really appreciate everybody's time here today, and don't hesitate to reach out to any of us if you have any questions about what we covered today or any of the areas that we can help you with. All right, take care, everybody.
Thank you.
Thank you all.
Thanks, everyone.